We've had a question about estate agency, saying under the new rules, or outcomes we should say, will firms that have an estate agency be permitted to act for the buyer as well as the seller? Perhaps I should open that up and say that, of course, firms can do estate agency through their law practice, and that will continue. And in the handbook itself, there is a specialist set of rules for property selling, and you will want to look at those if you do it as part of your practice. They don't mention conflicts specifically because the outcomes in Chapter 3 deal with that. The outcomes would not allow you to act very routinely or as a matter of course the buyer and seller, but you would need, I think, really to judge conflict in the same way as you would with any other conflict. If you have a separate business, then you will deal with things in that way through the separate business, which won't be regulated by the SRA, but your connections between the separate business and your firm will be subject to regulation. Thank you for that. Okay, are there any more questions on the telephone, please?
If you wish to submit a question via the telephone, please press star 1 now and wait for your name to be announced.
Okay. We've had a question by email saying the new principles do not seem to really address relationships between professionals. Now, I'm not quite sure what's meant by that. No. Maybe you could clarify that and we'll do our best to answer it, or if you'd like to send us an email on that, we will post the response on the website after this. Any more questions?
There are no further questions from the audio at this time. Please continue.
Thank you.
Oh, my apologies. We do have one question. Please stand by while we collect their name.
Thank you. Okay, any telephone calls? Okay, we can deal with another question on the email, which is from a gentleman asking, many lenders are restricting their solicitor panels at the moment. Establishing beyond doubt that borrower and lender need separate representation would surely be good for the profession and its insurers. I think we appreciate the commercial pressures on the profession at the moment with regard to conveyancing and lenders, and we are talking quite regularly with the Law Society, who are in discussions with panels, with the Council for Mortgage Lenders.
And I think it's worth adding that we have to regulate in the public interest rather than the profession's interest and the interests of the insurers. And so, given, I suppose, the cost implications of having separate representation, there needs to be a balance really between the savings gained financially in having the same firm acting and the risks of conflict. And I think the general feeling at the moment is that the savings probably in most cases would outweigh those risks in most straightforward mortgage transactions.
Thank you. Is our telephone caller on the line?
Yes, we do have a question from a Mr. Michael Scott. Please go ahead, sir.
Thank you very much. Yeah, very, very interesting so far. Thank you. Someone asked a question about the relationship between different professionals, and it wasn't my question, but it just sparks in my mind a query that if you have an ABS, there's a multidisciplinary partnership between solicitors, accountants, actuaries, IFAs, or whatever it might be, how will the various different regulators deal with that, and how would the SRA deal with, for instance, having accountants in, say, an MDP that is predominantly solicitor-led?
What I would say to that is watch this space, because we are in discussions with the other regulators. We're reaching an understanding with the other regulators as to how that will work, and that will be published shortly.
Yeah, we are in the process of drawing up memoranda of understanding with various other regulators. I think MDPs are possibly the most complex form of ABS. There are so many issues, and one of the big issues has been client money, and the effect of the accounts rules is going to be that money relating to legal services will have to be kept separate from money relating to the other business activities of the ABS.
But is it anticipated that, say, if you have a solicitor-led MDP, that the SRA would be the primary regulator, and that would be the first port of call in terms of any complaints or regulatory issues?
Well,
Not complaints, because that goes to the legal ombudsman, but any sort of regulatory concerns.
I don't think really the proportion of solicitors is the relevant issue, because once a business is carrying on reserved legal activities, they will have to be licensed by us, and so we will in effect be regulating the business in terms of those activities. Where you've got non-lawyer participants, the situation is more complex in terms of the extent to which we regulate individuals. So as individuals, they will be regulated by their own regulator if they are indeed regulated, and really our regulatory reach only extends as far as the legal activities of the firm. So there are going to be some very complex setups and some very complex regulatory arrangements.
So when do you anticipate those will be in place?
Well, colleagues are working on it now, so it's going to be published very shortly, early next year,
right,
I believe. And it will be published on our website, in the Freedom in Practice section of the website.
I see. Well, thank you very much for that.
Thank you. Another question on the email forum is, will the same outcomes regime apply to ABSs when they launch in October 2011? And the answer to that is absolutely yes. One of the core requirements of the new handbook is that it applies as much as possible to ABSs as it does to traditional law firms, so that everyone is regulated in the same way.
Yeah, and that's very much the reason for introducing OFR at the same time as ABSs, so that ABSs and traditional law firms are all subject to the same regulatory regime.
Thank you. Another question that's come through is, if the basis is outcome-based and therefore based on judgments made by firms, how are judgments made going to be justified or meet the satisfaction of the SRA? This is really what we were talking about earlier in the presentation. Indicative behaviours give you guidance as to how you meet the outcomes. If you choose a different way of meeting an outcome, then you will need to justify, or you may be asked to justify that to us. And it's purely by way of demonstrating that your methods suit the needs of your clients and they've met the outcomes. So Jenny gave you the example of client care. We've given some indicative behaviours about how we think you can meet outcomes of treating your clients fairly and making sure that clients have proper information. You may find for your particular client that there is another way in which you can meet that outcome, and you may just be asked to explain that to us and justify it to us. But we would never rule anything out until you've explained to us how it best meets your client's needs.
We're certainly not trying to catch people out in terms of complying with the outcomes. You know, if there's a good reason for your approach and it works and achieves the outcomes, then that will be acceptable.
Yeah. Someone's emailed in a follow-on from the telephone question, so thank you very much. Is it envisaged that there will be MDPs, multidisciplinary partnerships, with a minority lawyer relationship? There could well be, isn't there?
Yeah, there's no restriction at the moment in terms of legal disciplinary partnerships. There's a restriction on the number of non-lawyer members, but certainly with ABSs there could well be a situation where there's, for example, one lawyer and 99 accountants. And as long as that business is carrying on reserve legal activities, it will need to be licensed by us.
Thank you. A question there. Let's have a look. How will the SRA be monitoring firms' compliance with the new Code of Conduct? Will there be visits to firms? The answer is yes, there will still be visits to firms, but what we are also doing is a lot more desk-based supervision, as Jenny mentioned before, identifying risk, dealing with things on a desktop basis. So the way in which you interact with us in the future is not to be assumed to be the same as it is now. Are there any more telephone calls?
There are no questions via the audio at this time. Please continue.
Let's have a look and see if there are any more email questions. Yeah. A few people are asking still about conveyancing. As we've said before, with conveyancing, it's neither the intention to restrict or relax the current provisions, but what we are trying to do is make analysis of conveyancing more outcomes focused, so that you judge whether or not it's appropriate to act for seller and buyer or lender or borrower based on your own analysis of the different interests, the need to negotiate and circumstances like that. Okay, we seem to be reaching the end of the email questions coming through, and there aren't any more telephone calls. So that leaves us to say thank you very much for taking part in this webinar. Thank you very much.
Thank you.
Thank you. That does conclude our conference for today. You may now disconnect from the audio portion of this event.